Okay, let's begin with our session today. Very good afternoon, one and all. I welcome you all on this another session on POSH training, that is prevention on sexual harassment. Hi, I am Anu Bhatnagar, webinar executive, and I welcome you all for this session today. So, primarily in this session, we'll discuss about certain things. What is this all about? We'll discuss about the concept of prevention of sexual harassment, what from where it came, how it functions, and other things. And there are certain landmark cases which we'll deal in this particular session today. So, also in the end of the session, we'll take doubts from our audience. So, if anybody would be having any doubt, you can write in a Q&A tab. From there, we can take your queries. So today, as a guest speaker, we have with us Smeeksha Pandey, ma'am. She is an advocate at Supreme Court. So I welcome you, ma'am. And before we start our session, let me just introduce our today's expert. Ms. Smeeksha, ma'am, is a graduate from MIT Noida. She did her BLLB and specialization in IPR. Also, she did her master's from Hidayatullah National Law University. Currently, she is practicing at Delhi High Court and Honorable Supreme Court of India. She is currently dealing with family matters, and her practicing area is broadly into civil matters. So we have a lot to learn from you, ma'am. And without any further delay, let's begin with the session today.
Thank
Over to you, ma'am.
thank you for such a kind introduction, Anu. Happy Diwali to one and all. I think this is a very recent session after Diwali. So let's go ahead.
Yes, ma'am.
So basically, why POSH and why we should discuss this. So with coming up of work life and having to go out, work, or anywhere, we all of us, irrespective of the gender, we need a sense of security and we need a healthy environment to work in. I mean, it is whether with your colleagues or your senior or your junior, there has to be a sense of understanding and a very healthy environment. And how to uh, understand that okay, this act is not a healthy act, or this comment is a regressive comment, or there are certain acts or gestures which are double meaning. I mean, at workplace especially, it is like, what is POSH is prevention of sexual harassment at workplace. So in order to understand that what is a healthy uh, criteria where a bond can exist, and what is like out of limit, or maybe a rigorous or a running comment. So it not this act not only helps you to know and specify them, but it has also preventions, redressal, and cures for them. So it sometimes happen that obviously the workspace has to be friendly and everyone needs to be good to each other, but then there has to be healthy limits and healthy boundaries set for that. So in order to do that, and what is not healthy and what is unhealthy to do or to say or to act in a certain way which makes the other person uncomfortable. See, for example, A is passing, just saying that, okay, Samiksha, today what are you wearing and what is it about? And if that is making me uncomfortable, then it is surely is. So we have to always understand that, okay, what is healthy and unhealthy. And I think this, after discussing this entire PPT and the act, I think this will help us a lot with understanding, not only understanding, but then what solutions we have to this. Because obviously, healthy boundaries are never at loss, and it will only help in a proper communication and better workplace environment. So, with this summary, let's begin with today's topic, that is the prevention of sexual harassment of women at workplace. So basically, I must say that I am very gender neutral person, and it can happen to anyone irrespective of the gender. So this act has to go a long way when it comes to gender neutrality, because it's not only about women, it's also about men. But for now, we have only saving women first. So let's go ahead with it and come to the purpose of this act. So it is about protection of women against sexual harassment at the workplace and for the prevention and redressal of the complaints of sexual harassment and for the matters connected therewith of thereto. Let's come towards the foundation of POSH Act, that is the international law. Human rights by international conventions and instruments. Convention on the Elimination of Forms of Discrimination Against Women, that is CEDAW, which has been ratified on 25th June 1998 by the Government of India. In that CEDAW, which was a bill on women rights at different places, that to prevent women right not only at workplace but also at home, but we ratified it to have a base ground for POSH. Article 11 of the CEDAW clarifies that equality to employment can be seriously impaired when women are subjected to gender specific violence, such as sexual harassment at workplace. Let's go ahead and come towards the Indian law and how it find its base in Indian law, that is the Constitution. So, as enshrined in the preamble of the Constitution of India, equality of status and opportunity must be secured for all its citizens. Equality of every person under the law is guaranteed by Article 14 of the Constitution. Now, when we talk about Article 14 of the Constitution, we know that it talks about equality before law. The state shall not deny to any person equality before the law or the equal protection of law within the territory of India. Let's go ahead, and it also find its base in Article 15 and 21. 15 Article 15 is the prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth. So we will be specifically taking the discrimination on the ground of sex. That is, being a woman, sometimes we have to face certain comments, or maybe it is, see, the society is set up in a way where women are considered weak though they are not, but then there are sometimes regressive thoughts and we have to take unnecessary comments. But yes, tell a friendly, where we are taking it as a feedback or for a way of improvement, it is right. But then where it starts becoming fall or double meaning, then it becomes very unhealthy, and for those times we have to set a bar or a limit to it. Let's go ahead. Article 21, that is a right to life, and it not only constitute bare living, but it also constitute, that is, living with dignity, and which becomes a very important part here, that women are allowed to work in a healthy environment, and not giving them a healthy work environment is somewhere a breach of their fundamental right. Let's go ahead and move towards the reasons of this act. Sexual harassment at a workplace is considered violation of a woman's right to equality, life, and liberty. Now, with time, as you see, the digital activism has only given broader definitions to these terms of equality, life, and liberty. So, right to life with dignity and to have the kind of work and profession, that is Article 19(1)(g) should also be mentioned here, that it is not, these articles are very gender neutral, and it applies both on men and women, that they should get a perfect and a healthy uh, atmosphere for work. It creates an insecure and hostile work environment which discourage women's participation in work, thereby adversely affecting their social and economic empowerment and the goal of growth. Now, see what happens. By default, it has become important. I won't say that it is wrong, but by default, the household activities have become the prior uh, duty of a woman to do. Like, for example, in first instance, if we see any child doing wrong, so our first instinct is what? कि mom ने नहीं सिखाया. We never go towards the dad कि dad भी सिखा सकते थे या dad ने नहीं सिखाया. So I think the burden of household is somewhere by default come on women, but then obviously everyone is multitasking, including women, so they can balance out that part and work outside as well. So I think it nowadays there are no acts which are very gender specific, and all the acts and the work jobs are gender neutral, as far as it depends on an individual that how they take it ahead. Because if you see the organized sector, eh, the corporate world has major number of women coming up, and even if you see the construction sites, that is the unorganized sector, that also has major number of women working in them. So I don't think that in nowadays there is any gender specific occupation left. Let's go ahead. With more and more
Uh,
women joining the workforce, both
can we
in,
can we
yes,
take one question
yeah,
so
yeah,
that
sure.
it would be little bit more interactive?
Yeah, yeah,
There,
yeah.
yes, one question from Rajiv Singh Thakur. So he's asking, as regard to Article 15 in the Indian Constitution, how can we say that discrimination against the women is in itself a sexual harassment?
See, I'm not saying that every discrimination will turn out to be a sexual harassment case. But yes, I am saying that this article helps in crabbing any discrimination, any bar which is set to discriminate between the genders. It helps out to balance it out. But every discrimination doesn't lead to sexual harassment. And for that, we have elements further to decide that when it will turn out to be sexual harassment, when there will be explicit sexual content being shown, or those kind of, as I said initially, that on dressing sense, on your behavior, maybe discussing your personal life, that kind of instances. So we have very nicely marked instances in this act, and this act is very well versed among defining that which acts will lead to sexual harassment. Can
Right.
we go
I
ahead?
hope. Yes,
Yeah.
yes. I hope it answered to Rajiv. Yes, ma'am. Please go ahead.
Okay. So, with more and more women joining the workforce, both in organized and unorganized sector, ensuring and enabling working environment for women through legislation is felt imperative by the government. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, the POSH Act 2013. The bill was first introduced by Women and Child Development Minister Krishna Tirath in 2007 and approved by the Union Cabinet in January 2010. It was tabled in the Lok Sabha in December 2010 and referred to the Parliamentary Standing Committee on Human Resources Development. Let's see the legislative timeline of POSH Act 2007. Draft Protection of Women Against Sexual Harassment at Workplace Bill 2007 bill was approved by the Union Cabinet. 2010, the bill was introduced in the Lok Sabha. 2012, the bill was amended and reintroduced in the Lok Sabha. And September 3, 2012, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Bill 2012 was passed by the Lok Sabha. February 26, 2013, the Sexual Harassment of Women at Workplace, that is Prevention, Prohibition and Redressal Bill 2012 was passed by the Rajya Sabha. April 23, 2013, the POSH Act received the President's assent and was published in the Gazette of India as Act number 14 of 2013. And December 9, 2013, the Indian Ministry of Women and Child Development notified December 9, 2013 as the effective date of the POSH Act and POSH rules. Now let's see the most important landmark judgment, which is the basic judgment among all for POSH training. That is Vishakha versus a state of Rajasthan, and it is popularly known as Vishakha guidelines, based on which POSH Training Act found its base. So the guidelines were named Vishakha on the Jaipur-based NGO who have petitioned with other four women's activist groups. So the Vishakha guidelines 1997, sexual harassment includes. Now see here, already the definition starts here, and the same definition has been used in POSH training act as well. So just see that which are the instances where it will turn out that okay, this is a sexual harassment, and that will further answer the question. So the sexual harassment includes such unwelcome sexually determined behavior as physical contact and advances, a demand or request for sexual favors, sexually colored remarks. As I mean, let's get everything as an example. Behavior or physical contact, for example, touching, holding hands, or keeping hands on shoulders. These can be unwanted when you have not asked for. And see, for every level of bond at workplace, there has to be a limit. Everyone is not friends with everyone, and there is always a bar of seniority and juniors. So I think these kind of behavior when happens are, and it is an unwelcome situation. See, there is a vibe for every act. You know who is your friend, who can keep a hand on your shoulder, who cannot, and who should not. So I think every person has this conscious mind that okay, where it has to stop. So everyone has that developed self consciousness that okay, this is not something which should be happening. Or physical advances, that asking for some favor, maybe holding hands or anything, a demand or request for sexual favors. This is very much clear. Sexually colored remarks, like you are looking this way. Now your friends calling you that you are looking this beautiful, very stunning and all, and somebody from your workplace calling you at work hours is very different. So you know that in which environment and which setting one should comment or even compliment in a certain way. I mean, sometimes compliments, there are certain compliments also which make you uncomfortable if you are not up for it or ready for it. So even there is a very thin line between good behavior and when it turns unhealthy. Showing pornography, any other welcome physical, verbal, or non-verbal conduct of sexual nature. Now, for example, there is a business meeting with a client. For example, you are not in office, you are not dealing with any office person, but you are dealing with some client and you have to go for a business meeting. Now, to choose a place, you will be choosing a public place only. So in that also, choosing a place or somebody offering you that okay, we should meet here, which you feel that no, it is not related to your workplace, or it is not a good time or place to meet for work activities, then you can always ignore it and choose us as per your comfort and safety. Let's go ahead. And there is a very good example, in fact, a case which will be coming up, that there was a judge who was under training, a lady judge, and she was asked to dance by a senior judge at his son's birthday party. Now, these kind of when requests are being made, you know, this is not a very healthy request to make. I mean, she will be becoming a judge. You cannot ask a junior judge to dance at your son's birthday. So I think this is a very famous landmark judgment ahead, and we will be discussing it. Let's go ahead. Sexual harassment as defined at the workplace should be notified, published, and circulated. So nowadays, the workplaces have become so active that they have a proper report on every year complaints which are coming up, and to what extent all the complaints have been dealt, tackled, and solved. So there has to be a record maintained about it. Let's go ahead. Where such conduct amounts to a specific offense under the law, the employer should initiate appropriate action by complaining with the appropriate authority. So whenever these kind of acts happen, first you go to the internal committee, and when internal committee has done all the investigation internally and submitted a report, then only you can take that report to the court if you want further legal action to be taken place. So victims of sexual harassment should have the option to seek transfer of the perpetrator or their own transfer. An appropriate mechanism should be created for redressal of the complaint. Let's come to apparel export. Promotion Council versus AK Chopra, 1999, the Supreme Court enlarged the definition of sexual harassment by ruling that physical contact was not essential for it to amount to an act of sexual harassment. The Supreme Court explained that sexual harassment is a form of sex discrimination projected through unwelcome sexual advances. For example, sometimes in corporate, some scenario came where it have asked that okay, you will get promotion on certain and certain unwilling or unhealthy demands. So in order to get promotion, some people do that, but then that is a part of sexual harassment, and this is what it means here, that it cannot be direct physical, but then it can be a kind of request or a proposal made to you: in order to do something you have to do this, or get something you have to do this, those kind of requests. So, sexual harassment is a form of sex discrimination projected through unwelcome sexual advances, request for sexual favors, and other verbal or physical conduct with sexual overtones, whether directly or by implication. Sometimes there are blind comments also made that okay, this and this person, but you can make out that we are talking about whom, or we are told not to take name, but there is a gossip going around about someone's life or someone workspace. Since we are working in an office, at a point of time we start knowing everyone, that who is what kind of person, so we can really judge that what is right and what is wrong. I mean, I think if I am working in an office over an year, so by looking at my colleague face, I can see that he or she is having a bad day or a good day, because I mean, your office people and your workspace people know you in that way, that okay, this is a good day for you or it is a hard day for you. Let's go ahead. So the court explained the sexual harassment is a form of sex discrimination projected through unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct with sexual overtones, whether directly or by implication, particularly when submission to or rejection of such conduct by the female employee was capable of being used for affecting the employment of the female. This is what I was talking about, the promotion thing, or maybe you are maybe one is sometimes asked to, in order to get something or in order to get a bonus, you have to do overtime work or a certain handle a certain project which you really don't want to handle in first place, of the female employee, and unreasonably interfering with her work performance, and had the effect of creating an intimidating or hostile work environment for her. Let's go ahead. Medha Kotwal Lele and others versus Union of India. The Supreme Court observed that the implementation of Vichaka guidelines has to be not only in form but also in substance and spirit, so as to make available safe and secure environment for women at workplace in every aspect, and thereby enabling working women to work with dignity, decency, and due respect. Not being satisfied with the implementation of the Vishakha guidelines, it directed states to put in place sufficient mechanisms to ensure effective implementation of the Vishakha guidelines. Finally, Supreme Court asserted that in case of a non-compliance or non-adherence of the Vishakha guidelines, it would be open to the aggrieved person to approach the respective high courts. So this is what I was saying, that the first step is always internal committee of your workplace. Let's go ahead with important definitions, and let's see who all come under the workspace and its important definition. Yeah, yeah.
Yes, yes.
Let's go.
As we are discussing about whole acts of sexual harassment and everything, and we also got to know how the investigation and everything will work. We have one question from the same attendee, Mr. Rajiv Singh Thakur. So he's asking, like, how exactly would court determine whether act was proper or improper? And he's asking about what would be the test to find improper act, is victim's testimony or circumstantial evidence?
See, a victim testimony is not the ultimate truth, because sometimes there are use of law and there are misuses of law as well. So I'm not saying that the victim's testimony will be the gospel truth, But yes, we will be considering, and it will be first the internal committee will be analyzing the situation and report. For example, sometimes it also happens, for example, if I belong to a lower caste and somebody calls me by an uncertain name which lower castes are being called, then that also becomes a part and discussion of this act, that a woman is being called like this at workplace. So there are various certain instances, not only touching or asking direct favors, but indirect comments, making obvious, trying to discuss some any woman's personal life when she doesn't want or she is not comfortable, making her work for late hours if she is not comfortable after a certain time. So these kind of situation where the working atmosphere affects her performance or working atmosphere intimidates her, those are the instances where it will be considered as sexual harassment. But obviously it is not always that what a woman says. An internal committee is set, and within a certain day and time both the parties are allowed to put their points, circumstantial evidences are considered, and then only a final report is made and it is solved. So whatever a woman says is not the ultimate end. There is always an internal investigation which takes place, and I have discussed the detailed process ahead as well.
Right, ma'am. Yes, so as we discussed about the internal committee, another question is coming from Arpana, and she's asking like if there is an internal committee, right? So how they actually work if there is no witness, or we can say a direct witness to this.
Okay, so yeah, it might be possible that there are only two people and there is no indirect witness. In that case, also we see the history of their bond and how it has evolved over the time, because they might have past clashes at will as well. It is not always about male boss and female employed. Sometimes vice versa, female boss and male employee. So it is, as I said, that the gender neutral thing, and either of the genders can be a victim in this. Though this act prevents women, but it has a long way to go, as I said in the beginning only. So, in case of no victim or no direct evidence who have seen it or witnessed it, then we will be consider their the evolution of their bond, their history, that they have any old enmity and everything. See, either of the party won't get a final say in it. Only the entire investigation process will only decide. And generally in these kind of situations, what happens that one of the parties is being transferred to the other branch
Right,
to
ma'am.
solve the kind of issues.
Yes, ma'am. Also, if you can relate this particular thing and let us know what could be the remedy for this particular situation. Like, for example, two colleagues are traveling for a business meet, and one colleague makes a sexually colored remark on the other one, and this incident has happened for the first time, for the very first time. Then, how this all will work, and like so.
Okay, so if it is the first time, or a lady employee has felt that okay, this kind of comment should not have come up, maybe, so she can go and uh, bring it to the knowledge of the internal committee, since it is a comment and they will see the what is the best they can do in this situation. Maybe there will be a warning, maybe that other person will be asked to give an apology in writing, and as per the seriousness of that incidents and how it has to be tackled, the internal committee first internal committee asks the parties individually that okay, what was the situation. Then they are made to sit in front of each other to have final discussion that okay, what is it, and that they both are on the same page and know about each other story. And then as per the seriousness of the consequence, the final report will be made.
Right, ma'am. Yes, understood. Yes. Okay,
Okay,
please go ahead.
yeah, so let's come towards important definitions in the act. So section 2A, that is aggrieved woman, can be a working woman visiting a workplace or a student. Section 2F, employee. And within the definition of employee, there are various kind of employees. Let's domestic worker, regular, temporary, ad hoc, daily wager, for remuneration, voluntary basis, otherwise, that is internees and all, employed directly through an agent who comes on contract basis, contract workers, probationer, trainee, apprentice. Section 2E, domestic worker. Domestic worker means a woman who is employed to do the household work. Now we discuss this point very less. We always stick to a corporate world when it's come to POSH training, but POSH training is equally usable for those who are working in household. We often see that the maids are not being treated nicely and the maids are being beaten sometimes, and there are various unhealthy practices going on with the maids, so they are also covered. Their safety and prevention is also covered under POSH training, because for them the household are workplaces only. So domestic worker means a woman who is employed to do the household work in any household for remuneration, whether in cash or kind, either directly or through any agency on a temporary, permanent, part-time or full-time basis, but does not include any member of the family of the employer. Section 2H, internal committee, means an internal complaints committee constituted under Section 4. Section 2N, sexual harassment, also defined by Vichakha judgment, that is the physical contact and advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. Let's go ahead. Other acts amounting to sexual harassment are mentioned in Section 3, Clause 2. The following circumstances, among other circumstances, if it occurs or is present in relation to or connected with any act or behavior of sexual harassment, many may amount to sexual harassment. First, implied or explicit promise of preferential treatment in her employment. I have already discussed this, that you have to do a certain act to get promotion or certain act to do bonus. And if you don't want to work on a certain kind of project and you are forced to work on it, and but this is a very open to interpretation instance, that there might be some project where really your talent is needed maybe, but then you will know when it will be unhealthy in that process. Implied or explicit threat of detrimental treatment in her employment, implied or explicit threat about her present or future employment status. That is, sometimes we say, sometimes employees get to hear that, okay, I will be writing comments about you, and for your maybe character certificate and character detail is always taken from an old office or your old workplace. So in that case, that okay, I will be giving a wrong comment about you or a wrong feedback, that can be very detrimental and leading to mental harassment as well. Interference with her work or creating an intimidating or offensive or hostile work environment for her, or humiliating treatment likely to affect her health or safety. So I have also covered with keeping in mind that we are doing work from home, and this year is all about that. So let's see that if work from home is a part of POSH training or not. So it is. See section 2. Even if you are physically at home, but you are working for your office like from 9 to 5, then you will be considered that you are at your office only, whether you are physically at home. So is work from home covered under POSH law? Work from home is covered under the POSH law. The meaning of workplace also includes work from home under Section 2 of the POSH Act. While employees may be physically at home, they continue to operate in a workplace when interacting with colleagues and companies. Let's go ahead. Who all are covered under work from home? Consultants, freelancers, interns, volunteers, trainees, probationers, anyone visiting the virtual workplace. For example, we have created this virtual workplace environment right now. So within this webinar, which we are attending, where I am the panelist, Anu is there and the attendees are there. So this is a workplace for 1 hour for all of us. So if I am misbehaving or anyone is misbehaving, then we have to take care of it. Let's go ahead. Sexual harassment at virtual workplace. Discussing an employee's personal life. Now we are here to discuss sexual harassment. If we started pointing out each other's life or started discussing that, okay, if you have felt anything, now you don't want to discuss it here or it makes you uncomfortable, it can be unhealthy to discuss personal matters or personal experiences here. So this will lead to an unhealthy environment. Personal life and partner on official calls or through personal chats. Sharing screenshots taken while on video calls and making comments on appearances. For example, we start taking screenshots and later on we use it for our personal needs, or maybe letting the other person down that, okay, you were looking a certain way and you asked a silly question. So these kind of bullies should not happen. Sending inappropriate messages, sharing sexual jokes, links, explicit content on WhatsApp. Digital stalking. For example, one of us, see, it is a new group and we are all new people communicating. Now, one of us, either of us, started stalking the other person on everywhere, Facebook, LinkedIn, Instagram. So this can be a little uncomfortable for us or either of us that, okay, this is happening. Unnecessary use of emotions. Now let's come to the duties of employer. So the employer plays a very important role when two parties come in conflict of this nature. So we will be discussing each role and duty in detail to establish an internal complaints committee. So just give me a minute. So in order to establish an internal complaint committee, an employer must establish an internal complaints committee, that is ICC, at the office or branch where at least 10 employees are working. An ICC needs to be constituted even if there are no women employees working. And this is important because it is a gender neutral act which can happen to any gender. Though this act only specifies women, but we have to save both the gender, all the genders, irrespective of it.
Ma'am,
Then, yeah.
yes. So as we are talking about the internal complaint committee, and also we had discussed about that the domestic worker, like for example,
Yeah.
maid who comes to a home. Sudipta is asking like, what would be the IC or internal committee for that domestic worker?
Okay. So most of the time, if you see in big cities, what happened that there are agencies who appoint a maid for a house, and that maid remains there for 1 or 1.5 months, and then the maids are on leave. After 1.5 month, the that maid will go somewhere to other house in the nearby, and other maid will come, and this is how the agencies keep shuffling them who are registered with that agency, ensure that their safety also, and plus to handle that uncomfortable or unhealthy situation if the maids are have been suffering in that particular household. So if they are registered with any um, agency, then they can go to that agency complaining, and the owner can take whatever legal action is suitable for to help that maid. And if they are independent maids, then I think they can go for directly filing of complaints to police station. And obviously they are not that well aware about their rights and duties, so it somewhere becomes the NGO's role or the people, the legal fraternity people, to come forward and help in such situations where they know that something wrong is being happening in your nearby household.
Right, ma'am. Ma'am, following this question, we have a similar question asked by Arpana, and she's asking like if internal committee doesn't come on any conclusion, so is there any higher authority which deals with the similar thing?
See,
authority to internal
It is
committee.
very important for ICC to at least file a final report whether they are able to solve it or not. In case they are not able to solve it, then also the victim has an option of going to the court directly then under sexual harassment thing. So there is no higher authority above ICC, then only there will be legal proceedings.
Right, ma'am. Okay, please go ahead.
Yeah. So if there are no women employee working at the establishment, the employer needs to constitute an ICC at every office or branch of the company where 10 or more employees are working. The second is to implement a well drafted POSH policy. Now, sometimes what happens when we are making a contract or any kind of policy, even the bank policy, we are tend to just have a sample from internet and cut, copy and paste. But then POSH policy is not a standard. POSH policy won't work for every organization. It will also vary from the nature of the organization. That is, one organization have a different kind of nature, so they will follow and make a different kind of POSH policy than the other organization which has a different work profile. So the employer has the obligation to put in place a well drafted and customized anti sexual harassment policy drafted by an experienced employment and labor lawyer in India. Copy paste policy or a policy copied from the POSH template policies available online would not work, as these policies do not meet the actual standards laid down under the Prevention of Sexual Harassment Act 2013. To treat sexual harassment as misconduct, the Anti Sexual Harassment Act states that any instance of sexual harassment must be treated as misconduct. The employment agreement, service rule, policies, and procedures and standing orders must clearly state that sexual harassment will be treated as misconduct. The repercussions of sexual harassment must also be clearly stated, like deducting wages, termination of employment, additional penalties, etc., to display the consequences of sexual harassment. The employer must exhibit the penal consequences of sexual harassment and the order of the internal complaints committee at a clear, visible place at the place of employment. To sensitize employees regarding sexual harassment at workplace, all employers have the responsibility to apprise and sensitize employees regarding the issue of sexual harassment. The employer must conduct workshops and organize seminars to raise awareness among the employees regarding workplace sexual harassment. The central government rules under the Sexual Harassment Act require the employer to participate in the following activities, that is, circulate the POSH policy against sexual harassment at workplace, execute orientation programs for members of the internal committee, and conduct capacity and skill enhancing seminars for the ICC members, carry out awareness programs and forums with women groups, Panchayati Raj, local authorities, etc. Report the names and details of the ICC members in the prevention of sexual harassment policy. To prepare the annual report, I have already mentioned it that every corporate company has to prepare an annual report, that how many complaints were there and how each complaint has been treated and attained, what is the final result of every complaint. So the companies, societies and trusts are required to file an annual report regarding the sexual harassment complaints received and their current status. The companies registered in India need to file this annual report with the registrar of the companies. Societies and trusts needs to file this report with the charity commissioner or registrar of societies. However, sole proprietorship, partnership firms, and LLPs do not need to file their annual report. Rather, they need to inform the district officer appointed under the POSH Act about the sexual harassment cases filed with the organization and their status. to assist the employee is in reporting the incident of sexual harassment. The employer is also responsible to aid the employee in filing a complaint against the accused and help her in taking a legal action, including a criminal measure. The employer may also choose to initiate a complaint against the accused if the woman employer desires. So the sexual harassment has been held as a violation of the constitutional rights. Let's go ahead. Constitution of Internal Complaints Committee. Presiding officer to be headed by a woman employed at a senior level at workplace from amongst the employees. Two representatives from employees committed to the cause of women or have experience in social work or having legal knowledge. One member amongst NGO or associations committed to the cause of women or a person familiar with the issue relating to sexual harassment. At least one half of the total members so nominated shall be women. Advisable to have odd number of members in the committee. Internal committee, that is virtual place ready. Challenging times demand internal committees to be at par. So dedicated email ID, that is online mechanism for employees to file a sexual harassment complaint is important since it is an year for work from home. SOPs, that is standard operating procedures for virtual inquiries. Confidential cloud system to document false statements and evidence filed to enable virtual signing, and confidentiality agreements for online redressal. Let's come towards the procedure for resolution, settlement, or prosecution of acts of sexual harassment in the offline mode. So, step one is a formal complaint to the chairperson, presiding officer of the internal complaints committee constituted by the management. Step two, the aggrieved woman shall submit 6 copies of the complaint to the ICC. So, see, if you see, it is a well versed step and it has a very time limitation as well. It is not like that if you will be complaining, so it will be going like a civil procedure for ages. No, it has very well versed and very crisp system where you can get a solution very handy and you can have a safe work environment. If you see the step one, you are directly going to the presiding officer who has most of the authorities at a workplace. Then step two, the aggrieved woman shall be submitting 6 copies of the complaint to the ICC along with supporting documents, the name and address of the witness in writing. The aggrieved woman is required to disclose her name, department, division, and location, etc. The chairperson to contact her and take the matter forward. So everywhere you will be personally involved in the process to know that what is happening. Step 3, ICC shall send one of the copies to accused also in case that what the accused think about it and how he wants to reply to it and form his reply. So you see, both the parties are getting a chance to express themselves and it is not an arbitrary process. So ICC shall send one of the copies to accused, that is responded, within 10 working days. Let's go ahead. Step 4, the accused shall file his reply to the ICC along with supporting documents. Now he is also getting a chance to express himself and to bring to notice and light that okay, what instances might would have lead to it. Documents and the names and addresses of the witnesses within a period of 10 working days from the date of receipt of the documents. Step 5 is at the time of inquiry, a minimum of 3 members of the ICC, including the chairperson, shall be present. Step 6, the ICC shall conduct such investigations in a timely manner and shall submit a written report containing the findings and recommendations to the employer within the 10 days from the date of completion of inquiry. Step 7, the employer shall act upon the recommendation within 60 days of its receipt. And step 8 is the complaints committee report will also be made available to concerned parties. Let's come towards the end. Punishment for false or malicious complaints and false evidence. This is also I have included to just tell you that okay, it will save women in the first place, but then it know that every law comes with some loopholes or some situations which are obviously unwanted. So where the internal complaint committee arrives at a conclusion that the allegation against the respondent is malicious, or the aggrieved woman or any other person making the complaint has made the complaint knowing it to be false, or the aggrieved woman or any other person making the complaint has produced any forged or misleading document, it may recommend to the employer to take action in accordance within the provisions of the service rules applicable to her or him. And with this, we come to an towards the end of the webinar, and let's see what are the questions which are there. I
Right.
can see many questions. There are 10 questions already.
Right. Yes. So thank you for sharing such a wonderful insights, and we got to know about the functions and the very importance of POSH in this virtual world. So let's quickly take certain questions. We have three questions from Sudipta Sarkar, and she's asking if you can please share examples of POSH policies which are very different in the same sector.
Which are very different in the same sector.
And yes, further, and how copy paste of POSH policy has an adverse outcome.
Okay, so if you see online that how to prepare a POSH policy, you will see there are two, three standard format. But what happens that if legal sector will have certain different POSH policy than the construction sector. If you are working in a construction sector, it is an all-time job, and you have to see that what weight a woman is allowed to carry, how she is being behaved at the construction site. I mean, and according to the education level, also the POSH policies will matter, that she is not being harassed, she is not being called names. I mean, at construction site, there might be instance of fighting, and she might get hurt, and be, anyone can throw stones at her. So construction site will definitely protect the woman working in construction site very differently. But when we come to legal side, we will make policies like, okay, these are the decent working hours. There is a certain case where if a lady advocate don't want to go, then she is allowed to do so for her own safety first. And there are, if there is a certain client, sometimes clients also behave in a certain way, shouting that okay, this order was not asked for, and you should have said this in the code, that in the code. But then every way of expression has to be in a defined and well framed manner, because lawyers also do their best to, and they also want their clients to win only. But there are instances where sometimes lawyers express in a different way and clients express in a different way. So clients have to understand that it is for their goodwill only, and it is for their favorable situations only.
Right. Understood, ma'am. Her another question is, what about a small company with no women employee at a senior level? Then who presides the internal committee?
I mean, if at senior level, at senior most level, there might be no women, but if there are women working in that organization, there will be someone senior among them. So she will be presiding a company, and it is a very preferably said that half, especially in odd numbers in the committee, women should be available. And if there are no women, then also ICC committee will be framed for future and for the safety of the employers. So irrespective of women being there or not there, ICC committee has to be there.
Right, ma'am. We are taking one question from Q&A tab, and this is a follow-up question from Rajveer. And he's asking, like, we all have seen that there is a presumption under Evidence Act under Section 114A, right? So he's asking, so is it the duty of defense to rebut the same, and how exactly this presumption is being misused?
Actually, every allegation which is made has the other party has the right to rebut it. If the other party is not taking their chances of rebutting it or just letting it go, then obviously it will be a problem for them. So irrespective of section 114 of Evidence Act, every allegation which is made on a particular party has to be rebutted by that party in order to put forward their side.
Right, ma'am. Another question is from Anoop, and other attendees asking, is it necessary for a company with 19 branches across the country to set up a ICC at each branch?
See, it is important because as we say and we have discussed that, okay, if at any branch any problem like this occurs or any situation like this occurs, so one of the employee get transferred to the other branch, and there has to be a proper record made because it has to be submitted annually to the companies and to the registrar of the companies.
Right, ma'am. So yeah, as we also discussed that the offense regarding the stalking and everything. So
Yes.
there's one question from Rajiv is coming, that when somebody put his or her picture on the social media, so certainly they give their consent to their followers to see the same, right? Then how seeing those pictures would amount to stalking? If you can please justify this.
That won't be stalking, of course. And as you see that this sexual harassment acts are very restricted to workplace. For example, there is a fellow colleague to whom you are not talking, or he is commenting in a certain way, or he is sending a certain remarks which should not be there, then it can lead to an unhealthy situation. So I don't think that which is open to everyone creates a problem, but when some individuals start taking an action or crossing the limit which he or she should not, then it becomes a problem.
Right,
Like
ma'am.
you always see, and I think all the girls and women have gone through that, as soon as they upload one recent picture and there will be five DMs waiting for them, saying hello to you. Now
Yes.
even that sending hello is not a problem, but then after that, if there is a certain compliment or a certain comment which should not be there, then that becomes a problem.
Right. Understood, ma'am. So we are getting one question, and Aparna, and this is very interesting question. Like as we have seen generally, like there is a sexual harassment against two different genders. Like male is doing the same with another woman. So she's asking, have you ever seen such cases where women had filed this case of sexual harassment for against the other one, against the same gender?
Against same gender. See, the act is also silent on it, and actually, when it comes to the open-mindedness of society, it has a long way to go when it comes to the same gender issues. So I think all the acts which are about sexual harassment, even if you say IPC or this, they are silent. So I think there are no such complaints, though there are complaints of running commentary and maybe gossiping, which is a general habit of both the genders, I would say. I mean, gossiping is no more restricted to women only, men equally do it, though it is restricted in general. As I say that some characteristics are generalized to women, that okay, these are women's characteristic or these are men characteristic, but I don't think that present scenario is such, and everyone is equally intelligent and open to every situation. So yes, means I personally haven't come across any such complaint as such. But yes, this is very interesting, and we should take proper legal action towards that and think about it to have that those kind of clauses in law.
Right, correctly said. Sudipta is asking one another question. She's asking like, what are the typical actions taken by the IC besides termination? What other actions are taken? Like, if the offense is grave but not enough, that merits termination. Like, apart from termination, what other grounds are there for this?
See, a written apology is there, a transfer of one of the employee, whoever is open to get transferred, or there can be further legal proceeding if the victim wants that no, she wants to go ahead with the legal. Then in that case, also the employer goes forward with the ICC complaint report to file a case. So it totally depends on the victim's choice.
Right now. Yes, we have another question from anonymous attendee, and
Okay.
he or she is asking for your suggestion, like, so is there any source for men to become more aware how to behave in a workplace? I mean, like, the question could be, so in the business, in the at the workplace, so is there any sort of guidelines or something like that to, behave or something,
See,
or
I think when we talk about a good behavior, somewhere we have been taught that kind of behavior from childhood only. कि नहीं ऐसे नहीं बोलते, ऐसा नहीं करते. So whenever something is happening, so I think it is very embedded in a culture as well, that of how to behave is very well defined in our culture, because every time one is being corrected that okay, you have to say this, behave this
Hmm.
way, wear this. So I think we know, and somewhere we whatever happens knowingly. I mean, this law and these kind of incidents are open. Sometimes women also go ahead, and for their profit and for their money making process, they go ahead with false and malicious prosecutions as well. So for that also act has well defined it.
Hmm.
And so I think it is a very gender neutral. In the initially also I said that though the act says women, but it has a long way to become gender neutral. So I think men have a tendency, and they know that okay, you cannot be over friendly, or you don't have a somewhere say in what a woman is wearing to office. Obviously women know, and they I think I haven't seen any women wearing something unwanted to workplaces. So after that also, if they we first in first place, I will say that women take care of their safety. They
Hmm.
always have that on their mind that okay, I shouldn't be wearing this to office, this is not an office appropriate, or this is not, in spite of that, if something is happening, so men should at least make it that easy that they don't go ahead with the commenting part. I mean, running comments or maybe discussing, gossiping, they shouldn't be indulging in such things. I mean, there is always a different way to approach and bring to someone's notice something.
Yes, correctly said. Yes, ma'am. So we have taken all the relevant question, but one question we are getting again uh, regarding the domestic workers. So as you
Okay.
said that in the metro cities there are certain agencies which are attached to it,
Yeah.
but there are certain domestic workers who are not attached to internal committees agency. So what remedy is there for those people who are not connected to IC?
Yeah, as I mentioned, that maybe the neighborhood is aware about it, or the owners themselves and the household owners themselves can take the precautionary step and to take the maid to police and file a complaint for her safety.
Right, ma'am. Okay, participants, if you have any question, you can also raise your hands. Also, you can ask any question if you have directly to our speaker. We can wait for few more seconds if anybody has any question regarding POSH. So they can post either in Q&A or in a chat box. Okay, I guess we have taken all the relevant question and now participant doesn't have any query. So before we sign off, I would definitely ask you the best way forward. If you can please tell us the best way forward for this particular prevention on sexual harassment. So please say a few words on that. And also participants, share your feedback with us for this session, how you find it. And please give your feedback on the scale of 1 to 10, 1 being the lowest and 10 being the highest. You can.
Yes, please, you can send your feedback in the chat box itself so that I can also see. And yeah, my last words, like my last would be that, oh, see, when we are going ahead with an open and broad mindedness, so gender neutrality is something which should be our embedded in our character. It is very important that we don't judge ourselves, our female other colleagues, and we don't judge men also. I mean, it is not always all men are not same, all women are not same, and it goes uh, like in a general thing that situations can happen in a certain where women can be also victim, they can also be the main cause of the incident happening, and vice versa for men, that men can also be the victim and men can be the main cause and the source of some happening something unhealthy. So I think we have to be very open to the situation, and not, and you have to always think out of the box. I mean, this is a time where we have to be very open, and I'm not saying that it is being open and being understanding, being gender neutral is not equivalent to being liberal. So I mean, everywhere I think we get this term liberal and it is being used like that. So when it comes to liberal, it goes to religious thing. I'm not talking about being liberal, but I'm talking about having an understanding for both the genders. And this is what we are most about, that even if you go for training, for POSH training or for mediation training, the first quality that we are asked to have is gender neutrality. Like, for example, I am a mediator in a course, so I just cannot favor blindly to the woman.
Hmm.
I have to very open to the understanding and the sufferings of the men too, who is involved in that incident. So I think gender neutrality can only solve half of the issues which we will be having at workplace. If we
Right, ma'am.
see that, okay, women are also working in the same office, men are also working, so obviously their intellect is somewhere equal. I'm not saying that who is higher or who is not, that will obviously their performance will suggest, but then yes, they have reached there with equal intellect, I am talking about. So I think treating everyone equally and open to understand them, not judge them in the first place कि हाँ आदमी ही गलत करेगा या औरत ही victim होगी or vice versa. So according to that, we have to see, we have to very specify to situation.
Right.
We don't have to carry our presumptions with us everywhere.
Right. Yes, indeed. And we need to rely on the facts and circumstances of the
Yes.
cases, indeed. So it was a very wonderful session. And thank you so much, ma'am, for sharing such a wonderful insights with us. And you comprehensively told us the whole act and showed us the relevance of POSH Act in this virtual world. And that's very important. I believe that many of us might not be aware that we are working at a workplace, at a virtual level also. So also we are getting a good feedback from our participants. So thank you participants for joining, and thank you ma'am for joining with Law Seco. Now I'll sign off, and stay home, stay safe.
Yes,
I'll
and
sign.
be safe at your workplaces as well.
Right.
Yes.
Correctly said. So now I'll sign off. Anu Bhatnagar, Webinar Executive. Thank you, everyone.
Thank you, everyone.